it's, right, let me see if I can see this. Wait for a minute. Someone will come on. Just wait for a minute. I'm supposed to hold up the flag, aren't I? Yeah, hold up the flag. Should be holding up the chiefs as well. But anyway, am I on there? Right, so we're up to the court case today. I know a lot of people will be out, but and so not many people will be watching. But I have to make 2 videos today. So in order to, we're getting behind and they're speeding up with all their laws and everything. And we're getting behind and we have to move quite quickly and we all have to develop our understanding. Everybody's kind of like halfway there to understanding where we're from, where we came from, what happened in the middle and why we're in the position that we're in now. And so we've got to go back to the 1840 court case. That we know that in the year 1215, the Magna Carta was born. When the Magna Carta was born, it gave absolute rule over all the people in England and actually around the world too, to the religious leaders. They took absolute power and they gave themselves the right, which were going to be the religious leaders, the kings, the barons and the knights were going to rule over all mankind forever and ever. And these were the laws that they set out and that they gave to God. That was the Magna Carta. So you've got to stay. And then for 400 years, there was a 400-year battle by the slaves to get rid of it. Now, they did actually throw them all out. And and then they had an independent person come in, Oliver Cromwell, who was neither king nor pope. And they tried that for a while, but he ended up being tyrannical as well. And so this battle has been going on for hundreds and hundreds of years, and we're right in the middle of it now. So we've got to understand what that battle is and what our battle is and what the middle battle is. The people rose up, the Lollards, rise of the Lollards in the Glorious Revolution, and they brought in a new king, but they said, right, kings, governments, popes, religious leaders, we don't care who you are, we're going to put you under this set of rules that we, the sovereign people, give to you. So you don't give your rules to us. We're going to give our rules to you. And if you don't follow them, then we're not going to give you our allegiance. And so from then it was peaceful because we had the sovereign rule, which was us. We had sovereign rule for another, another 100 years or so. We had sovereign rule, and that went not too badly. And then what happened is all those religious leaders moved out. Where did they go? They went to Australia, they went to Africa, they went to Canada, they went to New Zealand, and they went to America. And they set up their Magna Carta rule again. And that was called the law of the land. And then what happened was the British Empire realized that their glorious revolution was going to be totally under threat because all of these countries were now going to be under papal rule, religious rule, Israelite rule, and that they would have so many countries that the glorious revolution was going to be just trampled on. Because this is what we have to remember, is that the sovereign, the immoral sovereign, will constantly try to wipe out the moral sovereign. The moral state is weak and the immoral state is very strong, and they will always wipe us out if we let them. So that's why we had to establish these laws for the Protestant people. Now, we did have the court, we're in the court of day 2. So they were in New Zealand, and a lot of people don't know this. New Zealand, and as far as I know, Australia, but I'm just going to say New Zealand and Australia because everything is all focused on New Zealand and Australia at the moment. So this is our fight, New Zealand people, Australian people. This is our fight. It not anybody else's fight. It's ours alone. And we've got to stand together. Now, from my understanding, when the missionaries went to Australia and New Zealand, they took their papal rule and their religious rule with them. And they almost basically kind of owned the country. But they were still under British governance to a point. Because they had always worked together. The kings and the religious leaders in the parliament have always worked together. It's no good thinking that they were ever separate. They've always worked together, and in some cases it's been good, in some cases it's not been so good. So when New Zealand declared its independence, which was set up by the missionaries, and then the British Crown came to New Zealand to counterbalance that, and they set up the Treaty of Waitangi, and then 6 months later there was a court battle, and we're in the midst of the court battle now. Okay, and I just want to review that the last part we were on Wentworth, and Wentworth went to the court, and these were the points that he made, because the British wanted to confiscate all of the lands that had been bought by the missionaries and the church. And so the church didn't want that to happen. And the church basically wanted their cake and eat it. They wanted to have the British governance, because that was going to bring stability, and if they had stability, that was going to make profit for their businesses. But they didn't want the British government to take all of their lands that they had taken from the natives and bought from the natives. So they wanted their cake and eat it. And so this was Wentworth's argument about he had bought the entire South Island and most of the North Island, him and his associates. He had 5 associates, 5 or 6, he says. So he said in his summing up, the natives had the right to sell the land. The British subjects had the right to buy the land. And he said that they would accept the new law from 1840 onwards, but they would, and then any land sales after 1840 should be approved through a court system and a proper checks and balances. But they said anything previous to that, we don't want your investigations. We don't want you, and we don't want to give up any of our lands. But he did agree. He said he would accept that they open a court, and if there were any grievances from the natives, that they could go to that court and complain about it. But he disagreed that any investigations should take place over the thousands and millions of acres that the missionaries had bought. And him alone had bought something like 20 million acres. Now, the same thing happened in Australia, Southern Australia. So we kind of got to be looking for both of us here. So the next guy to come up is Mr. Beckett. But before we can go on to Mr. Beckett, what I'm going to do is I'm going to explain some of the things that are going to be talked about in here, and then I don't want to stop what I'm talking about to come back and explain them. So I'm going to explain them first, and then when I've explained, I can just barrel on through and tell you what goes on in the court hearing. And let's all remember that some people are new and they haven't watched the first 2, and let's remember that some people are not as fast as others. And I'm a gumboot lawyer, and I'm all about trying to make it understandable for people that aren't so clever. Maybe they can't read 1,000 pages of laws. So I just want to make it simple. Right. So one of the laws that was introduced into the court was called the Colonial Proclamation of 1763. And I have to explain to you what this proclamation is. When the missionaries went to Canada and America and all of those, let's all remember that New Zealand was the last country that they went to. So when the missionaries went to all of those countries, and when the British saw what was happening, the natives were starving, the natives were having all their lands taken from them, and they had no way of protecting themselves because they had no laws. What had happened was the British went in, and the British set boundaries to the lands where the Aboriginal natives lived. And what they said is, because they had to follow the 1688 Bill of Rights. What they said is, yes, you can freely travel across their lands, but you can't buy their lands or settle on their lands or stay on their lands. And so this was the way that they upheld people's rights, the right of movement of people, but they prevented the natives from losing their lands by what would happen is that the missionaries would go there under the law of the missionary church, but some of them would break free, and then they would make friends with the native chiefs, sometimes even marrying their daughters or having even children, and then they would negotiate to buy huge tracts of land. They were called adventurers, and then they would take those tracts of land and then they would sell them in pieces to people of England. And they told the people of England that there was a government in these countries when there wasn't. The people of England that bought the land innocently went there to settle, and the natives chopped their heads off because the natives were protecting their land, but those settlers had also bought the land. So this was all the stuff going on, that why this colonization took place. So it's not as simple as what you're saying, oh, colonizers. These countries were being decimated, but not everybody is innocent here, because there were many greedy chiefs that sold out their own people as well. The lands where their people were sitting on and settled on, they were selling them. And so there's a lot more involved here than just saying, oh, the white people come. So that was called this Colonial Proclamation of 1763. And many of the colonists were opposed because they already had lands in these places. So this is what the British were doing. Not only the British, I think there were a couple. I think the Catholics went one way, the British went one, and then the French took some. So I think they might have divided them up of how they were going to stop all of this shenanigans from going on. So they all took certain sections of the world, from my limited understanding. But the colonists, or people, they weren't really colonists, they were just called land adventurers. They had already bought all the lands from the chiefs, and so they were opposed to this proclamation because they wanted to keep their lands. And then the British and everyone was saying, nope, you've got to get out, but we'll let you have these other spaces here. Because let me tell you something, the world doesn't belong to anybody. And 200,000 native people in a huge country don't get to keep that entire country. Every single sovereign in the world is entitled to their fair share of the land. So however many people are, and however much the circumference of the earth is divided between each of them. We all are entitled to that piece. And so you can't say, I'm an Aboriginal and I own the entire continent of Australia just because we were here first. That's not even in God's law. So you can just forget about that. The world is for sharing. However, what they said was, what the British said was, what these people were living on, this is how much space that they get. So if there's 100 people, they get enough space of their share of the world of those 100 people. And then what was left over, they gave. So, and that's how they do it all. Now, I just want to quickly go into, 13 minutes in, we're going to go 2 minutes, the Magna Carta, which was section 29, which I really have to explain this to you because this is going to come up in the court battle later. So you have to understand it. The Magna Carta has a preamble, and in that preamble, it makes the free man. The free man were the popes, the kings, the barons, the knights, and everybody else was just a slave that worked on those lands. But them and their families owned the lands, distributed the lands, said who was going to work where, and they were the owners. They gave themselves power for all perpetuity. Section 29 says, no free man shall be disseised of his lands. Now, they weren't talking about you and me. This is pre-1688, and they were talking about the nobles that were the only ones that were allowed to own lands, and they were the only ones that were allowed to vote as well. And So what had happened for us in present day, in around about 1999, both Australia and New Zealand instituted Section 29 of the Magna Carta into New Zealand and Australian law. But Australia put that preamble, but New Zealand didn't put the preamble. Now, you have to ask yourself a question. In law, when you're going to use a law, can you use a part of a law and not have the preamble that's attached to it? And I'm saying no. You're going to have to make your own decision. I think that when you get an act, it is a whole document, and you can't just pick and choose the pieces that you like and throw out the pieces that you don't like. And so this is what they're trying to do nowadays. They're trying to create laws where they have lots of people, everybody gets a little piece in the law, and nobody gets nothing, because you are obliged to all of those pieces that you don't agree with, just as much as you are obliged to all of those ones that you do agree of. And so when they instituted the Magna Carta into New Zealand law, and in 2015, there was a reintroduction, there was a celebration of the Magna Carta at the Waitangi Treaty grounds. In around about 2000, the Majesty Queen Elizabeth's bronze statue was erected on the grounds of the Magna Carta, and there were protests over there. And also, what's I going to say about that Magna Carta? But anyway, there's been a push to bring this back. But everybody is focused only on the section, and they're not focused on the preamble. But the key is in the preamble of who are the rulers responsible. Now, they used the Magna Carta of 1297 that was instituted into Australia. So what I'm saying, when we go into this court hearing that we're about to go into in a couple of minutes, when we go into the court reading, they're talking about two sets of subjects. The first sets of subjects come under the Magna Carta of the papal and kingly and knightly and baronial rule. And the second set of subjects come under the 1688 Bill of Rights that were given to Protestants by God, which made it set all the rules that kings and queens and parliamentarians would have to follow in order to govern us. So that's how they did it. So when you go back to this court battle of 1840, these two laws are battling it out. We've got the Magna Carta of the missionaries, which is what the New Zealand Declaration of Independence was based on. And we've got the 1688 of the rights, which is what the Treaty of Waitangi is based on. So when you really keep this in mind when we go into the court hearing of which one we're going to do, and then if I can remember, I'm going to tell you which one that I'm talking about. Okay? So keep all that in mind. Oh, and this, the 1297 was enacted in 1986. In the 1297 Magna Carta was enacted in New Zealand and Australia in 1986, at the same time that our constitutions were removed. So this is what's going on. You have to understand all this. So I'm in the court case now. Hopefully the court case will be not as long. I'll try and go as fast as I can, because I know you don't all like watching. All right, so we're still on day 2, and Mr. Beckett is stepping up. This is extremely complicated. You very have to listen. He said he wanted to induce the council not to pass the bill. This Treaty of Waitangi was not a bill. It was just a signing document. It then had to be passed into law by a bill in New Zealand. It had already been passed into law in New South Wales. It had already been passed into law in England. They were waiting for the confirmation for it to be passed into law in New Zealand. and that would have sealed it. And this is what they're contesting. So the actual treaty itself is like a small part of this whole process, although it's at the same time it's a very important part. So this is, he said, to induce the council not to pass the bill, he said the Crown must take land only by discovery or by conquest, but that is not the case for the bill. So usually if the king wanted to take land, it had to be discovered or they had to take it by conquest, which is by war. But in this case, the Crown argument to take the land by the bill was founded on one man's, his name was Story, so it's quite hard to explain him, but I'm just call him a man. And this man was an American, and the Crown were presenting their case based on American law, but so that they could institute English law, and he said that's a conflict. He said, but however, to use this man's story as a precedent, this man, his name was Story, I'm going to call him Bob. This man, Bob, said that the American Indians were a race of beings debased in the scale of existence, that they were merely creatures of conquest. And this man, Bob, was based on the law of nature, which the law of nations is founded on. So this is what it meant, is that when natives were so debilitated, they had no laws, they were savages, they didn't have very much language amongst each other, they were killing each other, eating each other, slaughtering. They were considered people that needed to be conquested over, and they needed to be civilized. Now you might say, well, they didn't need to be civilized, but they were scalping each other, eating each other. So the moral state had to be protected from the immoral state. And that is a godly, worldwide, universal law. So that's why the American Indians were conquested, which is different from New Zealand. Now he's saying, but in the case of the Aboriginal inhabitants of New Zealand, they were intelligent, they had a rank of nations, their chiefs had been received by kings as sovereign beings, they had a language, and they knew how to apply their language. Therefore, they could not be considered to be savages. They understood what was sale and purchase, and they recognized the right of property. They were able to protect their rights by reason as well as by brute force. So he's saying that at the time that all the missionaries bought the millions of acres from the New Zealand natives, that the New Zealand natives were well aware of what they were doing, and it was their right. And the British have got no power to overrule that right. That's what he's saying. Beckett states that since Britain wanted to take care of New Zealand and claim a colonial status, then why, he's asking the question, why in 1839, when a ship was refused colonial register, based on it was a vessel built by a foreign nation and in correspondence was styled as a kingdom. Now, you have to understand what it means when a country is styled as a kingdom. When a country is styled as a kingdom, it means that it has a sovereign power that holds the basket of power from all of the sovereigns of the country. We are the sovereigns. Everybody gets one sovereign. And we, all the moral state, take all of our sovereigns and we put it into the basket of the king, and the king enforces the law of the moral sovereign state. And so if they were recognized as a kingdom, that means that they were recognized as a sovereign state. And no other nation had the right to go into a sovereign state and interfere with their land sales, is what he's saying. In correspondence by the British government, New Zealand was styled as a kingdom, and up to the time Hobson came to take possession, the country has been written of and negotiated about as an independent state. He said, So presently in 1840, until the public are informed about Britain and the situation, then the country had the right, according to the law of nations, of rejecting interference in its internal government, as well as any attempts to control its subjects respecting disposal of inheritable and personal property among themselves or to the subjects of this dynasty. So just a quick recap. So he's saying that since they had a government and it was set up by the Declaration of Independence of 1835, they were recognised as a kingdom, recognised as a sovereign nation, as a kingdom, so they had laws, so they say, but they didn't, but they say that. He said that until the English government makes the announcement to the people that they are no longer under that 1835 to 1840 kingdom, until they make that announcement, everything that went on during that time is none of their business. And then once they've made the announcement, and if everybody accepts it, then everything after that is going to be to do with the chiefs and the British substance. The chiefs were on the side of Britain and all the tribes because they'd lost all their lands. They had lost everything. So they actually, at that point in time, not later, but at that point in time, it wasn't the chiefs that were fighting the British. It was the missionaries, because they were going to lose all their land, as they should. Now, where are we up to? Respect in attempts. Here he says, the Treaty of Waitangi contained 3 major points to the Crown. It purported to cede all rights of soil on the grounds that they natives are paternal subjects of Her Majesty. Since the Crown had used the Colonial Proclamation, which I just told you about, as a warning, one document nullified the other. So I'm going to explain that. When they used the Colonial Proclamation, it said that the land was to be given to be segregated for the natives, and it belonged to them, and then the colonial government would take over all the rest of the lands to keep everything in order. And he said that is that document, okay, which in that document it said that the natives were not capable of taking care of themselves in that country. And then he said, but the Treaty of Waitangi, where am I? In order for them to cede their rights of soil on the grounds that they are British subjects was in opposition to the grounds that they were savages and could have the soil taken by colonial rule because they were savages. So basically what one is saying that they had brains and they knew what they were doing and they had the right to do that, and one was saying that they had no brains and they didn't have the right to sell their properties and all of that. So the 2 documents were opposing, according to Beckett. He said in the Colonial adverts to a kingdom, and the bill styles it as a dependency of New South Wales, without showing by what it means New Zealand as an independent kingdom had become of the dependency of the British Empire. So I know this is complicated, so try and stay with me. New Zealand was stuck in a time warp. It was like all over the place. They had it as a New South Wales dependency, and then the British were claiming it as theirs through their right of preemption to take it as theirs. But how could they do that when it had to go through New South Wales laws? If it was a dependency of New South Wales, it had to go through their laws. But then if it was a British subject, it's going to be British subject, then how did that connect with the New South Wales law, which they used the Colonial Proclamation document for? And then they also had this Declaration of Independence that they were in fact a kingdom by themselves. So New Zealand was in quite a mess at this point in time. And very sad for the chiefs, because clearly I'm having trouble understanding even now, but can you imagine what it must have been like for the chiefs to understand all this? It was awful for them. It was even awful for the settlers that come out from Britain, because most of them couldn't read or write either. They were just people wanting to build their land. So this is how it was, that New Zealand was stuck between three countries. Was New Zealand a kingdom by itself because of the Declaration of Independence? Was it a dependency of New South Wales? Or were they British subjects and giving all their lands to the British British Queen, British Majesty? And so each of those decisions had a different outcome. If New Zealand was a kingdom of total independence, then all of the land sales to the missionaries were legal and binding, and nobody could take those lands back for them. No, not on hell or high water. Those lands were gone. Or if New Zealand was a dependency of New South Wales, then through the colonial document, their lands that they were settled on could be put boundaries around, and nobody was allowed to buy any lands on those anymore. There was still the dilemma of the people that had already bought the lands, but that's another story. And then they had the other position with the come from England, where, right, the Queen, the whole lot would go into the British Majesty's basket, and then she would reallocate the land as she saw fit. So this is quite the dilemma that everybody was facing here. He said the meaning on one bill, New Zealand is dependent of New South Wales, or the meaning that it was a colonial land which needed marcation, or if it was a legal dependent of the British Empire. These are the issues that he is contesting. So the mode in which the council, this is here, Beckett says, the mode in which the council was legislating the bill, which is the Treaty of Waitangi, was not in accordance with the New South Wales Act of Colonial Property. And he said, by which the council were authorised to make acts for the government of this colony only. So that's a bit of a problem for him. So the British colony with acts made by New South Wales law as a dependency was not legal, he's saying. The preamble of the bill showed, this is talking about the preamble of the Treaty of Waitangi, showed that the regulation of property in New Zealand in terms of the Treaty of Waitangi were not necessary. Because if the New Zealand deeds were null and void, then no law would be necessary to make them so. He's talking about their confiscation. But if the deeds were valid, that they had bought, then another bill must be passed to make them invalid. So that's what he's saying, is that if you're going to have this bill that all the lands are going to be confiscated from the missionaries, not from the chiefs, from the missionaries, then first of all you have to make a bill to say that you're going to confiscate, to make all of those land deeds invalid. And then you have to express why you're making those land deeds invalid. You would have to prove that New Zealand either was a colonial territory under New South Wales, or that New Zealand, you would also have to prove that it wasn't a kingdom. So he says before they can pass the bill, they first have to sort out these issues. If the deeds are void due to not being a government, then a law wasn't necessary. But if a law to confiscate was necessary, it's because those deeds are valid, therefore need a new bill. So it's a bit complicated. So here's the question. Are the deeds valid or invalid? Now, I'm not going to answer this question for you. I'm asking you. If you're a New Zealand Maori, if you're an Aboriginal, anybody who you are, they had the whakaputanga, which was the Declaration of Independence. And with that, they were permitted to create land deeds. And they did create land deeds. And then they sold the entire country. And the people that they sold to didn't take care of the people in the country because they were not allowed to. What you had was a Maori government that didn't know how to make laws, and you had an English ownership of all the land. It wasn't working out for them. So the question that you have to ask yourself is, were the land deeds of the missionaries valid or not? And if the land deeds were not valid, then that means New Zealand must not have been an independent country. Or if the land deeds are valid and you want to be an independent country, I'm not going to answer the question because I don't even know myself. So he said, because of these reasons, the Treaty of Waitangi Bill should not pass until these points are settled, being that, is it a kingdom or not? Is it an independent country or not? Are the missionary land deeds valid or not? These are the issues. And if they're not valid, then they could cede. If the land deeds were not valid, then they could cede the property, I think. And I'm almost finished on this one. If the bill did proceed, which was the Treaty of Waitangi Bill, to cede all the lands of New Zealand to the Majesty the Queen, it must become, now listen carefully, he said, it has to become a dead letter, which I don't understand quite what that means, as judges could not use the bill practically in court when these points would be contested. So that is saying that if all the lands were confiscated from the missionaries, if they were all put into a land court, the first thing that anybody's going to argue are these points. And so the bill is a dead letter because the judge can't use it, because he can't rule on any of these other points. And so he said that it's just going to be the Treaty of Waitangi is a dead bill because no judge is going to be able to rule over that, because people are going to keep bringing up these points. So that was his. So he said that this would create laws that could not be enforced by the courts, because it was never going to be up to the courts to decide whether New Zealand was a kingdom or not, or whether it was independent or not, or whether the land deeds were valid or not. And so he said they would send the problem from their council, where they were deliberating the Treaty of Waitangi, straight into the courts. And so he saw that, and I kind of agreed with him. He said the council would not feel right in passing a legislature which ultimately is legislating for subjects, not of Britain, but of a foreign state. And these subjects, now this is where we're talking about that the New Zealand Maori became subjects of the Magna Carta, not of the 1688 Bill of Rights, because under the Magna Carta, it is the absolute rule of kings and religious leaders. And New Zealand was governed by native kings, papal leaders, and missionary leaders of various different churches, the Israelite leaders, the Jehovah's leaders, all of those. That's how New Zealand was governed. So therefore, they were basically subjects of the Magna Carta. So he said that the council would be passing legislature which ultimately is legislating for subjects that are not of Britain but of a foreign state, over which the Crown has not previously exercised any right of lordship. I'm about to finish now. So his lasting point was, so he is not aware that the law of nations or British law that persons owing allegiance to Britain cannot buy land. That's kind of another issue. Don't worry about it. So basically what he's saying is, under the Declaration of Independence, New Zealand was governed in a Magna Carta style system where the chiefs and the kings and the religious leaders held all power over the lands and over the people. But the only thing here was the sneaky buggers, was that all the lands belonged to the missionaries and the religious leaders, and only the governance belonged to the native chiefs who didn't know how to control the missionaries who were just, you know, decimating them. So that was the one issue. And then the other issue was that they wanted to bring in the 1688 Bill of Rights to make all of the natives of New Zealand have those rights above the Magna Carta rights. So basically, the fight that went on in England 400 years previously, and actually if we're talking 1800, so we're starting in 1215, and the last Magna Carta was 1297, so the year 1300, and then in 1688, so let's say the year 1700, was 400 years later, we get the Bill of Rights where the people own the power. And both of these are forever documents, both of them. And then what happened is this war went out into all of the countries of England, of New Zealand, Australia, mostly New Zealand, Australia, Canada, and in America, the missionaries won. So that's what happened there, and that's why they have a different law to us. So we only got Canada, and I think Canada's even different. Australia and New Zealand, we got our own thing to worry about. Don't worry about them. But Australia and New Zealand, we're all tied up in this together. And this has significant meaning. If you're Australian, you have to follow this because this has significant meaning to you as well. So we don't know what's going to happen next in the court case. That's going to be the next one. So this, so from 1300 to 1700, the battle, and we've got the Glorious Revolution. So that is 400 years. And then we've got into the 1800s. So this is like a 500-600 year battle that has spilled out from England, Scotland, Ireland, France, Germany. It's spilled out of there and it's come to New Zealand and it's come to Australia, but it has specifically come to New Zealand. And this is the battle that we are facing today because they have reignited the court case in the year 2000. 700 years later, we are still fighting this fight. And we have in New Zealand Parliament and Australian Parliament still sits the 1688 Bill of Rights. And they, in 1986, reinstituted the Magna Carta. So they're both back. We've got some very serious decisions to make. Only us Australians and New Zealanders. If it is to be, it is up to me, or it's up to us to decide the future of our descendants. What are they going to have to deal with 500 years from now? That is what we're looking at. I'll see you later.